Welcome to the webinar entitled Cryptocurrency Fraud, Investigating, Managing Risks and Recovering Assets. My name is Syed Rahman. I'm a legal director here at Rahman Ravelli, and I'm going to spend around 5 minutes introducing this topic to you all. Now, with the firm being involved in some of the leading crypto asset litigation in the UK, this is a topic that I'm particularly passionate about, and I'm extremely pleased to be part of the panel today. Cryptocurrency and the use of blockchain is more popular now than it has ever been before. And as such, it has sent a real signal to the wider commercial world where investors are increasingly convinced that this is a long-lasting asset. We are seeing organizations, corporate bodies, and indeed governments in various countries investing in crypto assets as a means of diversifying their portfolios or to form part of their treasuries as a genuine alternative to your traditional fiat currency. However, many of you will be aware from a legal perspective, in particular in England and Wales, this is still an emerging area. We all know the use of cryptocurrency, unfortunately, is often associated with wrongdoing. One of the appeals for bad actors is the anonymity in cryptocurrencies. And I'm hoping after this webinar, we can dispel this myth because crypto assets can indeed be tracked, traced, and identified. We're going to look at crypto asset fraud from both a civil and criminal law perspective. And so we will aim to take you through the journey of how to plan these types of investigations, explain what strategic tools are available to de-anonymize crypto assets, and finally, how to safely recover your losses once you have identified the wrongdoers. This webinar will be focusing on jurisdictions such as US, Singapore, Poland, and of course, England and Wales. Now, I'm going to spend the next minute or two introducing our fantastic panel. But before I do, I just want to address a few housekeeping points. Firstly, this webinar will run for 60 minutes with an additional 15 minutes for Q&A at the end. We're hoping to give each of the panel roughly 10 minutes or so to speak to you. Secondly, all of the listeners will be on mute, but if you do have any questions, please submit them through the Q&A feature below. Our aim is to go through as many questions as we can after the 60-minute session. And finally, this webinar is being recorded and we will aim to circulate a recording of this session. And my understanding is that it is usually disseminated around 48 hours or so from today. So let's get started. First, we have Amanda Wick. Amanda Wick is the Chief of Legal Affairs at blockchain investigation firm Chainalysis. Previously, she served as a senior policy advisor at the Financial Crimes Enforcement Network, or better known as FinCEN. And before that, she served for nearly 10 years as a federal prosecutor for the US Department of Justice. And here she specialized in cryptocurrency, money laundering, and asset recovery. Next, we have Danny Ong, a partner at Raja & Tan in Singapore. Danny specializes in complex international commercial disputes with a track record in cases involving cryptocurrency. In fact, he successfully pursued the first cryptocurrency claim before the Singapore International Commercial Court. Adrian Andrzejowski is a senior associate at JDP in Poland. Adrian is a specialist in court proceedings associated with financial disputes, complex corporate litigation, and all aspects of cross-border trading. And finally, my colleague Josie Welland. She's an associate here at Rahman Ravelli. Josie formed part of the team and was involved in the leading case of AA versus Persons Unknown. She was also involved in the freezing of crypto assets in the case of Ion Science and others v. Persons Unknown, which I believe is the first ICO fraud case to be brought before the commercial court. Now, it was not long ago, on 5th of November 2020, the US Department of Justice filed a civil forfeiture complaint against the largest ever seizure of digital assets, collectively worth more than $1 billion US. Chainalysis played a key role in assisting law enforcement with the tracking and tracing of those funds. Because of the size of the case, discussions around seizing and recovering cryptocurrency have increased exponentially. Amanda, can you now just take us through a typical investigation process, including the resources and tools that are used to track, trace, and safely store crypto assets, please?
Sure, and good morning to everyone, or I guess good afternoon, depending on where you are. Give me 1 second. I think this may help. So good morning. As Syed said, my name is Amanda Wick, and I'm the Chief of Legal Affairs at a company called Chainalysis, Inc., and we are the blockchain analytics solution. We do quite a bit, but one of the primary things we do is we sell Reactor, a software analytics program that assists investigators. We also have in-house investigators. So when we're talking about investigating a crypto case, as Syed, I think you use the term track and trace, but that's very apt, and that's generally how we refer to it, is the tracking and tracing of assets. One of the things that you have to understand with crypto is that in some ways it's very similar to fiat, but in other ways, it can be very different. There's huge advantages to doing investigations in crypto, and that oftentimes, because transactions on most blockchains are public, imagine a ginormous public ledger where you can see all of the transactions up until the point where it ends at a service, right? So we can't track once it goes into a service like an exchange, and there are some ways that we can track through an exchange, but for the most part, you can't. But imagine if Danny, forgive me, were to rob a bank tomorrow, and he thought that a creative solution, to that was to go open 100 bank accounts, right? And he had done that, and he wired the funds from bank account to bank account to bank account, right? It would be very difficult for me. I would have to subpoena each of those bank accounts to follow that. But if Danny went on and stole a bunch of Bitcoin and then tried to open 100 wallet addresses and move them to 100 wallet addresses before he tried to cash those funds out in an exchange, I could see those in seconds on the blockchain, right? I could see the entire thing by just following the flow of money between those wallets. So when you're talking about cryptocurrency, the entire investigative process is different, and having an investigator who understands that is critical. So when you instigate the investigation, you're looking at, okay, where were the funds stolen from? Who were they stolen from? Usually you'll have a victim of some kind. And then you're basically following those funds from that person's wallet to wherever it ends up, right? And all that time you're collecting intelligence, you're evaluating that, and you're trying to figure out multiple goals. In most investigations, you're trying to do two things. You're trying to follow the assets, right? Because asset recovery, especially when you have a victim, is critical. But you're also trying to do something called attribution, which is just as important. Because the primary difference between fiat and cryptocurrency is that while I can go online and I can see all of the transactions on the blockchain, all I see is a string of numbers, right? I don't know who it is because there's not a name associated with it. So blockchain analytics software such as ours and other companies that have them, what we do is we provide visibility and transparency, and we attribute addresses so that in my hypothetical where if Danny steals a bunch of money, transfers it through a bunch of wallets, and then says, okay, I'm going to try to cash out at an exchange, which is usually what happens because most criminals want to use that money. And right now it's difficult to use it as a payment. So they try to take it out through an exchange. At that point, I can track down and see, okay, Danny sent all of his money to exchange X, and then I just need to serve process on exchange X to find out the who. If it's a quasi-legitimate exchange, right, they're going to have some kind of KYC, they're going to take some kind of identification, email, something that connects that to a person in real life. And now you've got attribution and you're working towards, okay, who's my target, who's my defendant, who's the person I'm trying to recover from. So at that point, I think other speakers are going to talk about some of the process that you can use on exchanges and court to kind of get that money. And you just need to be cognizant of a couple of things, which is the timing of this moves very, very fast. You can move massive amounts of crypto for pennies on the dollar instantly. So having a structure in place if you're going to do this is absolutely critical. This is not something that you can figure out as you go. You have to absolutely have somebody who knows what they're doing, who knows the process, who's done this before, because the nature of it is just exigent. Everything about it is going to move quickly and can disappear. So you need to kind of have these things in place before you're a victim, because otherwise, if you start to scramble, the money will be gone by the time you've made heads or tails. You also need to be cognizant of different jurisdictional issues, which I think some other folks will talk about. But whether you're law enforcement or whether you're an asset recovery specialist, once you've tracked that money, you've traced it, and you're seeking to recover it, the processes in different countries can vary widely. And you need to understand, like, there's a lot of technology that goes into seizing crypto. Whether you have a court order saying that you're entitled to the funds, if it's a civil case, maybe the person has to turn it over. But if you're in a position where somebody may have something funds stored in what's called an unhosted wallet, that's different than a hosted wallet that might be found at an exchange. If it's a hosted wallet at an exchange, the process is relatively easy. You can serve them with some kind of seizure warrant or process. But if it's an unhosted wallet, you may have difficulty, as law enforcement has, where the only person who might have the keys is the defendant. And then you have an issue of legal process in your country for what's your mechanism for getting them to basically turn that over. In some jurisdictions, they have plea negotiation processes. In other jurisdictions, they have contempt that can literally hold the person detained until they turn over these keys. But unlike traditional fiat, where there's no exact example other than maybe like a safe deposit box that they had swallowed or gotten rid of the key, right? But you can still kind of break through a safe deposit box. It's very difficult to get into a cold storage wallet or an unhosted wallet that you can't get the keys to. So that's something that you need to be very cognizant of and have realistic expectations of recovery. If you see that a funds went into a cold storage wallet, you need to be cognizant of that. And I know I'm using a lot of terms and I'm throwing a lot out there. This is kind of meant to be a high-level presentation. I strongly encourage, if you want to learn more, our website, chainalysis.com, has a ton of free resources for you to learn about this. There's a lot of free websites out there that can explain that. My email address is amanda.wick@chainalysis.com. Please don't hesitate to reach out if you have general questions. The other thing that I will say is that if you are either law enforcement or an asset recovery specialist, and you think that in your cases you may find crypto, one of the issues that was mentioned is, what do you do if you're trying to seize possibly $1 billion? And I will tell you, one of the situations that we see is that you really need to have a storage and realization method for cryptocurrency, because what we've seen in the last couple of years is that, yes, you trace and recover the funds. You are hopefully using an advanced software. I've seen some folks try to use public blockchain explorers, but that would be like trying to do Calc 3 with pen and paper and not use a graphing calculator. And when I say time is of the essence, having the tools that you need are really critical. But when it comes time to store it, we've heard horror stories of law enforcement and folks like basically throwing USB drives in a drawer of a desk that have millions, possibly billions of dollars on it, right? That's not what we would call secure storage. And as some of you may have known, there have been situations in the past where even law enforcement agents with improper security protocols have stolen funds. And as Syed mentioned, there are a lot of hacks that happen. So you really need to be careful if you're going to custody this stuff, that you have safe, secure custodians. We have a partnership program where we have a cradle to grave, track, trace, storage, and realization. This is an option if this is something that if you're looking at, but you really need to have a method for storing these assets and then how to sell them. We've been doing this for governments where we store and liquidate and then realize these assets, kind of like the function the US Marshals would serve for the US government. But this allows, if you're representing a victim, for you to ensure for your client that you recover the funds in a method that's as much as possible. And this can be basically usually some form of auctioning, blocks, etc. But I could spend hours on this topic. So when Syed said, you have 10 minutes or less, it's very difficult to kind of cover everything. But I think that's the general concept in terms of tracking, tracing, seizing, storing, and realizing. There's a lot that goes into this process. So let me stop sharing my screen, and Syed, I'll turn it back over to you.
All right, well, thank you very much for such a useful insight, Amanda. And given the recent seizure by the DOJ, I'm sure we're all agreed how important it is for law enforcement and asset recovery specialists to work jointly with private entities in order to identify a safe way to trace crypto assets. On that note, I think it's worth explaining and spending 5 minutes just to explain firstly what the current position is in the UK, secondly, the advantages and disadvantages of conducting civil actions versus reporting a criminal complaint to law enforcement in the UK. Earlier this month, the UK's financial services regulator, the Financial Conduct Authority, warned consumers, explaining they should be prepared to lose all their money if they invest in schemes promising high returns from digital assets such as Bitcoin. As the popularity of crypto assets are increasing, the Financial Conduct Authority's concern is that investors are unlikely to be protected and would not be able to rely on the financial ombudsman. Now, unlike the US, we've not seen many criminal prosecutions relate to cryptocurrency fraud. However, we have seen action in the civil courts. And one of the most common questions that we are always asked, in my experience, is if you should report the matter to law enforcement, or if you should pursue an investigation through civil courts, or of course, both. There are many pros and cons for both, and a decision is usually made based on the complexities of the case, the facts, and of course, various strategic considerations. Now, due to the time frame, I'll only go through a few of the differences for each. So let's first look at the advantages of civil proceedings. A great advantage in pursuing through the civil courts is the formidable relief that is available to you. And this could include, for example, various types of orders, including freezing injunctions. We've heard from Amanda, and we all know crypto assets move in milliseconds. And as such, speed in these types of investigations are imperative. Fortunately, again, the English courts have significant tools available to judges when you're dealing with urgent injunctions. And hopefully you'll hear more about that later. Next, in civil courts, the main aim is recovery or compensation for losses that you have suffered. And in addition to this, English civil judgments can be enforced in foreign jurisdictions. This means you can look to seize a defendant's assets, even if it is held outside of England and Wales. And of course, when you're dealing with crypto assets, that is likely to be the case. Finally, one of the biggest benefits is control. You have full control of the investigation and the proceedings. You'll appreciate in criminal proceedings, you lose that control. There is no guarantee of any prosecution, and you have no say in the investigation process. Now, let's look at a few of the advantages to criminal proceedings. Well, the biggest advantage is that law enforcement have wider powers of investigation. So this can include, for example, executing search warrants, obtaining telephone records, and other confidential information that is generally not available to the public. Whilst criminal investigations and prosecutions generally take much longer than civil proceedings, if the defendant is convicted, of course, they may receive a custodial sentence. And finally, if there are ongoing investigations against a suspect or a defendant in other jurisdictions, there may be provisions for law enforcement to cooperate and initiate what we call dual investigations. The two systems can often work together in parallel proceedings, and it's important to note that there is nothing to prohibit a criminal complaint following a civil claim or vice versa. So moving on then, in our experience, whether you're acting on behalf of an exchange, investors, or traders, the primary objective is quite often whether the assets can be recovered. So Josie, there are several remedies available in England and Wales at the early stages of an investigation to secure crypto assets. I've slightly touched on this, and we've already heard from the US perspective. Can you now take us through some of the offensive actions that are available through the courts in England and Wales, please?
Of course. First of all, good afternoon and good morning to everyone, wherever you are in the world. It really is my pleasure to be on this panel discussion today, and it's great to be joined by such a wealth of talent. Now, there are several effective tools available to judges in England and Wales to deal with cases concerning cryptocurrency. In this short 10-minute or so window, I shall outline some of the interim remedies that are potentially available where cryptocurrency is concerned, and some of the obstacles that you might face when trying to get them. Now, the problem with cryptocurrency, as both Amanda and Sid have touched upon, is that they can move very quickly. So if you find them in a certain place, you want and need to act quickly to preserve and get hold of them. The English civil courts and the tools at a judge's disposal are quite phenomenal at enabling you to do that. Across the novel cases which are and have and are developing through our court system at the moment, judges have shown a real willingness to adapt the existing asset tracing tools at their disposal to effectively deal with cryptocurrencies. So at this point, I thought it might be helpful to just show you on a table just some of the interim remedies that are available. So hopefully you can now all see on the screen just some of those orders. Now, this isn't an exhaustive list, but all of these orders represent the interim applications that can be made. So those orders that can be made before trial when you're dealing with cryptocurrency. And what I've purposely done here is included those that most commonly feature in cryptocurrency cases. Now, all of these orders can be made ex parte, so that means without notice. And what I've done here is set out the type of order, the effect of the order, and then the applicable test. Now, given I've only got a short window to talk to you today, I thought rather than talking you through each order and each test in turn, it's probably better to talk you through some of the obstacles. But what you can see here is that you have effectively two types of orders. You have the proprietary and the worldwide freezing order, and these are both the injunctive reliefs. So these are orders which are designed to help you preserve the crypto asset and or the asset of the wrongdoer. The second type of order you have are the information gathering type orders, which, as the description suggests, are those designed to obtain information which can lead you to the location or the preservation of the asset. So those are the Bankers' Trust, the Norwich Pharma Court, and the Iron Spartacus orders. Now, this might be a good opportunity for you to just take a screenshot of that table, because as I said, I'm not going to keep it up. If you don't have the facility to take a screenshot or you miss the opportunity, don't worry, because I'm assured that this slide will be made available with the recording of this webinar. So if I can just get my colleague to take down that screen. So as I said, there are a number of obstacles that you might face when you're trying to get some of the orders that just appeared in that table. They can be broken down really into three. One, what is cryptocurrency? Can an order apply to them? Two, who are you going to go after? Who's your respondent if we're in a scenario where we've got a wrongdoer or a fraudster taking place? And then three, where is the respondent? How do I serve the order on them? So what I thought I'd do is talk you through each of these in turn and how these might be overcome. So the first obstacle is, well, what is cryptocurrency? Now, this is quite a crucial question. When asking the courts to use their asset tracing tools, judges will want to know that they can apply the tracing remedy, so the orders such as what you saw in that table, against a cryptocurrency. Now, hopefully what you would have seen from that table, when you're looking at the injunctive reliefs that you're trying to get, so the proprietary injunction or the freezing orders, the two criteria for the first two criteria for either is one, is cryptocurrency property or is it property? And two, does the applicant have a good arguable case? So those are the two tests that you need to apply to cryptocurrency. Now, thankfully, there's now a string of English decisions, at least on an interim application basis, which recognize that crypto assets such as Bitcoin are property. The leading case on this is the case of AA versus Persons Unknown, which, as you've heard from Sid, is a case that we were personally involved in. Now, if you haven't read this judgment, then I strongly suggest that you do, because it is the leading case on cryptocurrency in the English civil courts at the moment. Here, Justice Bryan recognised that cryptocurrency is property for the purposes of the asset tracing tool he was being asked to grant in that case. Similarly, there are also a number of cases which have determined that there is a good arguable case when you are dealing with cases concerning cryptocurrency. So for all intents and purposes, that particular obstacle has now been overcome through case law. So the next question is, well then, who are you going after? Who is your respondent? Now, one of the main attractions of cryptocurrency as you've heard, is that they can be owned and transferred to some extent anonymously, so by persons that are unknown. So we have this scenario where a fraud has taken place, where crypto assets have been misappropriated in some way. We don't know who the bad actor or the wrongdoers are. So how do you say to a judge that you want he or she to make an order against an unknown person or an unknown entity? Now, the audience might think, well, you can't. But whilst we don't know who the wrongdoer identity is, that is, we don't know the person, say, behind the email who's trying to defraud you, but we can still capture them in the order as a person unknown. And in actual fact, the English court's power to issue claims and make injunctions against persons unknown is actually quite well established. Now, the leading case on this is a case called CMOC versus persons unknown. Now, this predates cryptocurrency, but it was also further endorsed in the leading case of AA versus persons unknown. Now, when you're dealing with an application against a respondent who is unknown, the crucial point is to ensure that the person unknown respondent is defined well. The authority states that the description used must be sufficiently certain as to identify both those who are included and those that are not. So it needs to be narrow and well defined. Now, the reason for that is because the courts will want to make sure that any order they make isn't too far-reaching and actually captures the right person. So how do you do this? Well, if you have a wrongdoer who has been communicating with you, say, through an email or a mobile number, for example, then when you are describing the respondent, the unknown person's respondent, then you would define them as the person who has communicated through X email address or Y number. And it just helps to narrowly define the order, and it gives you a greater certainty of the court granting the order. In some instances, as we've heard from Amanda, you can actually trace the crypto asset to an exchange. Now, exchanges will normally feature at some point during the course of cryptocurrency fraud. And that's because the wrongdoer isn't going to want to keep hold of the cryptocurrency asset indefinitely. At some point, they're likely to want to exchange it into fiat currency. So once you've got to an exchange, what do you do? Well, as Amanda sort of touched upon this, you can add them as a respondent. And the reason you do that is because you can't normally trace beyond them. Now, the reason why you do that is it's important, but the main reason is because of the information they're likely to hold. And that information can help you locate or preserve the crypto assets. Now, most cryptocurrency exchanges, albeit not all, are required to carry out know your customer and anti-money laundering checks on the account holder. Therefore, if you have traced the cryptocurrency to an exchange, you will then want to consider making one of the third-party disclosure orders. So, as those are listed in the table, like the Norwich Pharmacal, the Bankers Trust, or my personal favourite because of the name, the Iron Spartacus orders, in order to try and identify the wrongdoer or the onward transactions from that wallet. Now, all of these orders, one way or another, require the exchange and or the wrongdoer to provide information of the account holder and or the onward transactions from that wallet. All of these orders also normally come with a penal notice, which in the English courts can result in committal proceedings if you don't comply. Now, even if you're provided with a myriad of information and not necessarily the account holder, as Amanda identified, you don't necessarily always have that. All of the information that you get that's provided in accordance with these orders is always fruitful, because this additional information can either help you to further trace the funds, or in an ideal setting, help you to find an entity or an individual, which will help you to then find a route of enforcement, which is really our ultimate aim. So disclosure orders, again, are another useful asset tracing tool that you can utilize. Okay, so we've address what to do when you don't know who the wrongdoer is, or if you've ended up in an exchange. So the final obstacle to overcome, therefore, is, well, where is the respondent? How do I actually get this order to them? Now, crypto assets in the blockchain can be accessed anywhere in the world, and there therefore is an argument to suggest that it has no specific location for that very reason. So you're therefore also going to have to persuade a judge that he or she has jurisdiction to make that order. Now, the problem is that the wrongdoer on exchange are either likely not to be based in England and Wales, or you're just not going to know where they are at all. And the courts will want to know that they have the power, or as we call it, the jurisdiction, to make the orders that we're asking for. Now, the starting point is normally that you go against an entity or an individual in their home jurisdiction. So if you have an exchange that happens to be based in the BVI, then you would make the application in the BVI. So how do you explain to an English judge that they have the jurisdiction to grant the orders that you're asking for when the respondent isn't in England or you don't know where they're located? Now, in reality, in order for you to get around this, you have to think of some quite ingenious legal strategies. But there are two potential ways that we've dealt with this in the past. And from our experience, those are by getting permission from the judge to make an order to serve the interim remedy that you're trying to get to be served outside of the jurisdiction, and also by alternative means. Now, in order to serve out of the jurisdiction, the court must do so through one of the jurisdictional gateways, which can be found in the Civil Procedure Rules, Practice Direction 6B. So when dealing with cases concerning intended respondents who are overseas, or where their location is not known, careful thought must be given to how a case is going to be pleaded, and in particular, the possible gateway that could be used. In the recent case that Sid and I were involved in, Ion Science and others versus Persons Unknown, we're able to persuade the court in that case that it had the power under the gateways in Practice Direction 6B to make a banker's trust order for disclosure, and that was to be served out of the jurisdiction. Now, this case is interesting because in that case, the judge made it clear that he didn't want the case to act as an authority, but we were able to persuade the court that on the merits of that case, it did indeed have such a power. Now, a particular strength of a banker's trust jurisdiction as compared with the Norwich Farmer Court is that they can be granted against parties outside of the jurisdiction. So really, that is normally the route you'd want to go down. And this is particularly important to note, as in relation to AA versus Persons Unknown, the court was not satisfied it had the power to grant the disclosure order in that case because it was a Norwich Farmer Court that the claimant was seeking. Now, the applicant in that case, therefore, had persuaded the court to make the disclosure order ancillary to the proprietary injunction, that is, as part of the injunctive relief itself, and not a standalone order. Now, when I talk about alternative means, I mean serving the order in any other way other than by personal service, which is a normal requirement here in England. If the location of the person unknown or the exchange is not known, or it's not in England, then personal service may not necessarily be possible. So you need to apply to serve it in a different way. In AA versus Persons Unknown, when serving on the persons unknown, the court ordered that it could do so through an email address which was to be provided by the then third and fourth defendant, which were the exchanges. In the recent case of Ion Science and others versus Persons Unknown, when serving on one of the exchanges in that case, we actually managed to persuade the court to let us serve the order through one of the online support tickets. So whatever the circumstances, the mere fact that you don't know who the wrongdoer is or their location doesn't mean you cannot seek civil remedies. So to conclude, I hope that what I've just illustrated to you is that the English courts have a vast array of asset tracing tools at their disposal, and they are showing a particular willingness to adapt those tools to cases concerning cryptocurrency and crypto assets.
Thank you, Josie, and kudos to you for simplifying such a dense topic. I should also add that in our recent case of Ion Science and others, it was the first time the court considered the lex situs, or location of Bitcoin. Obviously, for the purposes of jurisdiction here, the court ruled that the location of the Bitcoin is the same place where the person who owns it is domiciled in, i.e. England and Wales. So that again was quite important. I'm going to be turning to Danny now, who recently litigated a very important case in the Singapore International Commercial Court. This case had a major impact in the crypto asset space This case also had a ripple effect and influenced the English courts in its understanding of the proprietary nature of crypto assets. Danny, can you talk us through the background of the B2C2 case and tell us about the key takeaways, including the impact this had in Singapore and other regions, please?
Yeah, so before I get into that, I mean, just to knock off one point following from Josie's and Amanda's presentation, is the fact that in Singapore, like in the UK and the US, the Singapore courts have no hesitation in granting interim freezing orders and disclosure orders to facilitate the recovery of crypto assets, and have consistently been doing so in the last 2 years. Having done that, let me turn to B2C2 versus coin. Why is the decision important? I mean, it's important on 2 counts. At first, it is, and this is the area that's really most talked about, it is the first time that the common law courts across the globe have examined the consequences of mistaken algorithmic trades in cryptocurrencies. In particular, how to ascertain knowledge of a party's claim mistake when transactions are executed through an algorithmic trading program. So this would have significance not only in the context of trading of cryptocurrencies, but trading generally where that is done through algorithmic trading programs, and one party claims that a transaction was consummated by way of mistake. The second significance lies in the recognition, just like the UK courts, and I'll come to that later on, the New Zealand courts have done, of cryptocurrency as property capable of being held on trust. And indeed, in that case, the courts at first instance had found a breach of trust on the part of the exchange for transferring cryptocurrency out of a customer's account, which was maintained with that exchange. The implications of the breach of trust point I will come to a bit later, but it would be significant in the context of asset recovery. Turning to brief facts, I'll try to be brief because it is a little bit convoluted, and I'll try to simplify. But in essence, B2C2 was a market-making firm dealing in cryptocurrency markets. Its core business was to provide liquidity on numerous cryptocurrency exchange platforms. So in essence, they quote buy and sell orders for cryptocurrency pairs within a spread of prices. They buy and sell orders placed on exchanges using an automated trading program. And that program was conceived by the founders and determined by algorithms. The algorithms essentially make decisions on what orders to be what orders are to be placed on an exchange based on a variety of factors such as current market prices, the volume on the exchange, the volume outside of the exchange, the portfolio's risk and exposure, and its own strategies and philosophies. Not very different from a traditional trading firm. Coin, on the other hand, they operated a cryptocurrency exchange platform initially founded in Japan, and then they had an offshoot called Coin Singapore. And they, like many exchanges, allowed users to buy and sell and trade cryptocurrency. Users would deposit cryptocurrencies with them or fiat currencies into their respective accounts on the platform, from which would then fund the trades. The trades would be processed by Coin's own trading program, but there are 2 important factors that led to the incident at hand. The first was that Coin provided margin financing to its own customers. So on the one hand, while it acted as an exchange, it also acted as a margin financier. And the margin traders and the margin trades were monitored by Coin's computer programs. Margin calls and false closures were automatically determined and triggered by its program. The second important factor relating to the incident was that it, apart from being an exchange, and secondly, a margin provider, thirdly, it acted also as a market maker and liquidity provider on its own exchange through a program called the Quota Program. So as it turned out and is discovered in the course of trial, the majority, up to 80% or more of the trades and the volume on the exchange were in fact emanated from Coin's own quota program. And very limited volume came from an organic customer trading activity or third-party market makers, including B2C2. So one fine day, Coin decided to change certain passwords for its platform systems, but failed to implement the necessary changes or corresponding changes to its quota program. That meant that in simple terms, the quota program became disconnected from the exchange and inoperative and stopped quoting on the exchange, its own exchange. That then drove to a low liquidity situation on the platform, and the volume on the platform started falling, right? As its own quotes got taken up by customers, customer trades. That low liquidity situation then triggered a margin call on the part of its customers who were on the one side trading margin, and Coin's own margin program, monitoring program, then force close on the basis of the low liquidity situation, force close its margin customers, and by force close its margin customers' open positions by buying Ethereum on the platform via market orders, meaning buying Ethereum for any price that may be sold on the exchange. So there was no risk management mechanisms which would have operated to limit the prices at which the force close orders to buy Ethereum would be met, or any monitoring at that point in time. So eventually the order book emptied as a result of the failure of the quota program, while the market orders to buy Ethereum were placed. And then B2C2's own proprietary algorithmic trading program detected the low liquidity situation and based on its predetermined levels, what we call deep price levels and the maximum price levels, decided to put a bid to sell, or rather to sell Ethereum for Bitcoin at what was then 250 times the prevailing market price. By market price, I mean the last transacted price, whether on the exchange or in the market. Coin's program on the exchange immediately matched B2C2's offers or quotes with the margin traders' force closure market orders, as a result of which B2C2 obtained what was termed to be by some to be a windfall of 3,000 over BTC at 250 times the prevailing going rate in the market of Bitcoin to Ethereum. So the trades now took place in the middle of the night. The actions were all carried out by the party's software, both on Coin's side and B2C2. No human was involved. The next morning, Coin reversed the trades and deducted the 3,000 Bitcoin that was already credited into B2C2's account. So B2C2 sued to recover the Bitcoin, firstly on the basis of breach of contract by reason of Coin not being entitled to reverse the trades, because there was a term in the contract that said that the trades were irreversible once done. Secondly, for breach of trust, because once the point being that once the cryptocurrencies were deposited into B2C2's account, it became held on trust. In the same way as equities were maintained with a brokerage account and held under that account would be held on trust generally for the customer, and the wrongful deduction therefore became a breach of trust. Coin essentially the main defense, or the main line of defense that was in contention really and subject to much debate, was that it said that the margin traders was under the mistaken belief that they were buying the Ethereum for Bitcoin at market prices, meaning what would be ordinarily available, but for the error on the platform and the quota program. And that B2C2 had actual knowledge, or ought to have known what in legal terms is called constructive knowledge of that mistake. So they needed to establish that the mistaken belief was something that was capable of a plea of mistake, which would have avoided the contract. And secondly, they needed to prove knowledge on the part of B2C2 of that mistake at that point of time of the incident. Now, so the question is, one of the key questions then is, how do you prove mistake on the part of B2C2 if it was in the middle of the night, no human was involved, and they were trading through this algorithmic program? Assuming that the margin traders were indeed under a mistake. And Coyne argued that, look, one need not be concerned with B2C2's actual knowledge and find out or make an inquiry about what their knowledge state of mind was, because the question should be whether parties hypothetical parties on a hypothetical trading floor would have known or likely to have known of that mistake and or intended for the trades to be consummated at those prices. That argument was rejected by the judges at both first instance and the Apex Singapore Court of Appeal, which was a 5-member tribunal comprising of 3 Singapore Justices of Appeal, Lord Justice Mans, as he then was, as he previously was, as well as the former Chief Justice of Australia, who said that, look, it's artificial to talk about hypothetical meetings and imagine the facts that way. And, you know, parties were content to contract through automated programs, so it's wrong to discard the programs. But that doesn't answer the question. So how do you solve the knowledge problem? So the questions were answered in this manner. Whose knowledge is first to be assessed? And it was found that the knowledge of the programmer or the person who ran the algorithm was the relevant party whose knowledge should be looked at, because the program was deterministic, meaning that it was pre-programmed to generate a certain output. And the question was, what did the programmer or the operator intend? The next question then, once you've done that, is when do you assess knowledge? And it was found that not at the time of contracting, but you look back at the time of programming. In that case, it was 12 to 18 months ago, I can't recall exactly, all the way up to the time the trade was executed. For as long as the intention or the mind of the programmer at the time of programming was excellent throughout to the time of the incident, then that level of knowledge was relevant. And when it came to what knowledge is required, it was found that it's not only actual knowledge, but what I had earlier mentioned, constructive knowledge, i.e. ought to have known. Was the trader in this case, is it the case that he ought to have known that the offer would only ever be accepted by a mistaken party, and was the programmer acting to take advantage of that mistake, all right, unconscionably? So on the facts of the case, there was no evidence that the programmer of the program ever had actual constructive knowledge of any mistake on the part of the margin traders. The Lord Justice Man was the international judge who sat on the Singapore International Commercial Court's Court of Appeal, disagreed with the majority. But I'll come quickly, I'm short of time now. What you might wonder after I've said all this, what is the relevance to cryptocurrency fraud asset recovery? I think it's important to, and this has been alluded to by my fellow panelists, it's not always the case that you have a hosted wallet whereby there is an identified host or a party who's known to you for which you can pursue and recover assets from, particularly in the context of crypto. The issue of knowledge then, but there is a potential liability on the part of other parties who may have processed the cryptocurrency transactions, facilitated the exchange into fiat or other crypto from Bitcoin to Ethereum to something else, facilitated and processed the transfers, facilitated trading with the fraudulently obtained crypto assets. Insofar as these transactions were processed via a computer program, there is a question and potential liability on the part of the operator of the program by reason of processing that transaction. And that liability may arise as a result of certain levels of knowledge being attributed to that operator or user of the program. For example, by virtue of the $1 billion worth of Bitcoin having been processed within the span of an hour through that program. And at that point in time, 1 year ago, when the programmer programmed that, did he contemplate or would he have suspected, i.e. ought to have known, that there was a possibility that his program would be used to launder the cryptocurrency assets. And if that's the case, and looking at in the context of a major exchange or a major cryptocurrency processing agency, would they actually face potential liability? A question that's not been asked of in the courts as yet, and not have not as arisen as I know it, but it may arise. I'll wrap it off by saying that in that case, cryptocurrency, as I said, was found and recognized as property that was capable of being held on trust, and the court found breach of trust at first instance on the other case in that B2C2 versus Coin case. The significance in the context of fraud asset recovery is that it is it lies in the availability of what we call proprietary injunctions, meaning a freezing order issued by the courts, which would over the cryptocurrency assets, the precise assets that have been lost or stolen from you, and then enabling you to trace downstream or upstream, whichever stream, into whatever converted assets they become. There is also the possibility in that context to order for the courts to order what we call specific performance. And this concept of cryptocurrency as property held on trust is particularly significant where cryptocurrency exchanges collapse or a cryptocurrency custodian collapses. Because it is in that context, then you would want to, as an owner of the property, distinguish yourself from an unsecured creditor. And that was precisely what happened in a New Zealand exchange called Cryptopia, which collapsed, for which the New Zealand courts found that the crypto of the customers were held on trust. So that's it from me. Over to you, Syed. Apologies if I overran.
It's all right, fascinating. Thank you very much indeed, Danny. Okay, so I'm going to quickly turn to Adrian, and hopefully in the next 5 or 6 minutes or so, you can, from an asset recovery perspective, can you just tell us about how crypto asset litigation is maturing in your jurisdiction and perhaps wider Europe?
Yes, Syed. It will be a pleasure to explain to such a wide audience this issue, although I'll have to be brief in this respect. So crypto asset litigation is a constantly emerging area in civil jurisdictions. As opposed to common law countries, there is still a discussion about the nature of crypto assets. This is linked to the fact that there is not much legislation about this issue. So far, only tax authorities have been quite fast to rule decisively on issues connected with crypto assets, but it's just in order to secure the tax base concerning any potential gains from the investments. In the current view of the jurisprudence here, crypto assets are not considered to be of a proprietary nature, just like the laptop to which I'm speaking now. They are also not considered to be the same as fiat currencies. There are, of course, voices that they should be considered to be of a proprietary nature, such as a house or a car. But there is still a long way to move from the voice of the legal profession to legislation. Now, actually, at this current moment, we lack any definitive answer on how crypto assets should be classified. And this has an enormous impact on any potential crypto asset recovery, and also raises many questions in terms on how should we litigate if our client has been a victim of a crypto fraud or scam. The only definition that we have under Polish law, and this is in terms of also European law, is that cryptocurrencies are virtual currencies which only act as a digital representation of a value which is exchangeable in commercial transactions and can be used as a means of payment if the parties agree to. At the end of last year, the National Financial Authority here issued guidelines on crypto asset regulations. Normally, you would think that this would resolve problem. However, what is interesting, the guidelines have 40 pages, and they do not actually define what a token is, and they also do not have any guidelines on any kind of civil or criminal proceedings and what to do in generally if we've been robbed of a crypto assets. So moving now to the practical terms of crypto asset recovery in Poland and in general in other civil jurisdictions. We always had, we also have the duality of proceedings, both civil and criminal. However, due to practical terms, civil proceedings is practically excluded to be used effectively. The main issue is that as opposed to the UK, case law, we do not have a possibility to apply for a versus person unknown injunction. In Poland, you always have to state the defendant, and you need, in not only his name but also his address. And there is also another issue connected with it, that this injunction will not follow him if follow the assets if they are transferred to another person. If they are transferred to another person, then I have to again apply for a separate injunction, and I'll be doing this for on and on. And before I manage to seize those crypto assets, they'll probably be just already abroad. So what I recommend, if you have a crypto asset case in Poland, is that you apply for criminal proceedings. They're very flexible. They allow for a general prosecutor's injunction, which can say that, which is both effective when the crypto assets are stored at a currency exchange, or whether they are stored at an offline wallet. If they are stored at a currency exchange, which is based in Poland, the prosecution will approach the cryptocurrency exchange and say, hi, I've got here an injunction, and now there are two possibilities for you. Either you oblige yourself to not do anything with those assets there, or you can transfer them out to a special wallet held by a designated custodian, or to a wallet actually organized by the prosecution. As if you have a situation where the crypto assets are stored at an offline wallet, the issue is a little bit more complex, but we can use general legal tools which are available to the prosecution. The prosecution can ask the person who is currently holding the stolen crypto to simply give the key, and if he refuses, he will be held, liable for contempt, and for obstructing justice. So, if you ever have a crypto asset case in Poland, you will be faced with the difficulty on how to organize an investigation. As said, you will be forced to rely on criminal proceedings, be it public or private from a subsidiary view. However, you can have some kind of control over the investigation, as the public prosecutors body in Poland can be generally quite cooperative in such cases. And if you, for example, have, let's say, knowledge of where the crypto assets are, or you have reports of special investigative agencies as to how to trace those assets and where have they been going to, then of course you can submit it, and you can give during the proceedings all the time any kind of hints or advice to the prosecution bodies on how the case should be conducted. In terms of other jurisdictions, the approach is fairly the same. In Europe, I think that only Switzerland has the most progressive approach. They classify crypto assets pretty much the same as fiat currency. So it's if you are misappropriated of the funds, then the proceedings there do not pretty much differ from any kind of fraud proceedings under civil procedure.
Right.
So that concludes my presentation here on this one.
Fantastic, Adrian. Thank you very much. What I want to do is, hopefully we've got quite a few questions here, so perhaps now is a suitable time to just go through as many questions as we can. Let's see the first question. So, is there any way to identify the virtual assets of a fraudster if you only have his personal details? I understand there is technology that allows tracing and attribution of identified crypto assets, but I have yet to hear of technology that can identify an individual's virtual assets as a whole. Amanda, I think you might be the appropriate person for this question, if that's all right.
Yeah, so this is an interesting question. And the answer is sort of. There are things that you might be able to do, and this is why kind of, so we have an in-house investigative service. This is why I think, so two things. Earlier, I think Syed or somebody mentioned the importance of kind of working concurrently with law enforcement and the private sector. And so sometimes law enforcement has tools that like the private sector does not. Sometimes we work in conjunction with them. This is why kind of like those dual tracks are really important, because you do need best in class investigators. But at the same time, there are things that law enforcement has that we don't. Now, having said that, you'd be surprised what personal detail, what you can find online in terms of OSINT or social media pages that can be used. There's a lot of information that can be gathered. So the answer is sort of. It's a much longer discussion. Feel free to reach out to me to continue it.
Fantastic. Okay, next is, how effective have Iam Spartacus orders been? I can't imagine that a fraudster would be inclined to identify him or herself. Well, you're absolutely right about that. And this is why generally these types of orders are served in addition or alongside the other orders that Josie mentioned. Josie, I don't know if there's anything that you want to add in addition to that.
Yeah, I mean, obviously there are going to be instances where, a fraudster or wrongdoer isn't going to identify themselves, but the purpose is that that tool does have other useful benefits to it. So in this new era of accountability, an order is as an important document to hold up to the world to show that you've done everything you can, everything in your power to mitigate the potential impact of, I don't know, say a hack and against the individuals involved. And that will help you not just to deal with your relevant regulator, for example, but also in the civil courts, if you are kind of much later down the line faced with the prospect of group litigation or, I don't know, representative action. So it has a dual purpose. Obviously, in an ideal world, the order will force the fraudster to identify themselves. And actually, you'd be surprised, because often we build a case theory about who is the wrongdoer. But actually, once you start this process, the order aimed at the Iam Spartacus, that individual might just be, as we found with our defendant, was a bona fide purchaser. So it helps you to build a picture. So they can come forward, but if they don't, there are other benefits to it. So I do certainly think it's worth pursuing.
Brilliant. There's just a comment here from Sam Goodman, who's actually in the CMOC case, and he's working with us at the moment on a separate matter. And he says, an Iam Spartacus order worked in the CMOC case, and one or two defendants identified themselves. Okay, great. Moving on then, let's see here, what do we have, anything interesting? Is the custodian responsible for loss of value of the assets he is storing? Well, I know in England and Wales, the applicant will have to consider some sort of limited indemnification, but Adrian, perhaps you can tell us really quickly about the position in your jurisdiction.
Yeah, so very quickly, the answer to this question is yes. The custodian is under a legal obligation to hold the assets which he has been, given by the law enforcement in such a way that they do not lose any value. It is up to him on whether he puts it at an exchange or whatever he does with it. He's under a legal obligation not to have those assets lose their value. If he's careless or anything like this and they lose their value, he will be liable towards the victim and also towards the law enforcement for not carrying out his duty in this respect.
All right, okay, thank you. Next question, how would you defend some of the interim remedies and orders mentioned? Well, there are some grounds to discharge freezing orders, and this really does depend on the merits. And so you would look at, for example, risk of dissipation, or whether it'll be just to continue the order. In fact, Josie and I worked on a matter where we challenged jurisdiction. Perhaps Josie, you can tell us about that, maybe.
Yeah, so to give you a case example, when we were defending in AA versus persons unknown, our primary defence, as I sort of touched upon in answer to the other question, was that the client was a good faith purchaser of the crypto assets, and that they had no knowledge of the alleged wrongdoing that was being put by the claimant. But we also ran a more technical defence, and that related to the jurisdiction of the order. So it was submitted in our argument that the English court did not have the jurisdiction in that case, and that Justice Bryan had used the incorrect gateway to serve the order out of the jurisdiction. So the gateway used was Gateway 9, a claim made in tort for damages. But in actual fact, when the case was pleaded, it was a case of constructive trust and restitution. And this argument actually led to negotiations, which ultimately resulted in the settlement for our client.
That's right, yeah, fantastic. Okay, let's see what else we've got. Okay, what liability might exchanges have if they don't identify potential bad actors moving ill-gotten assets through that exchange, or if they are not able to move quickly enough to respond to a freezer because of how quickly someone can move assets? What steps can exchanges take to monitor for such activity? Well, I know from the UK perspective, or certainly England and Wales, there are follow-up, as Josie mentioned, penal notices that we can ensure are followed up. So the orders from England and Wales perspective are generally quite draconian. So if you don't comply, then there will be follow-up action against the exchanges if obviously they've not acted accordingly. Danny, I'm conscious I've not asked you a question yet, so maybe you can follow up on that, or you can take on the next question. It's a matter for you.
Yeah, I'll just add on. I think there's a difference between deliberate non-compliance as compared to a situation where you have received the order, you've given instructions to put in place. It does require time because a lot of it would require, for example, changes to a certain system and tweaks to be made. And in the meantime, for some reason, out of your hands, the transfers do take place and you are not able to prevent those transfers. I think that in those situations, I think it would be difficult to find fault with the party or the custodian involved. But I do think that, from a custodian's perspective, I think along with AML, quite apart from AML, I think at the back end, operational end, the size of the trades, certain risk management measures can be put in place, whether it relates to trading and movement, or as it relates to compliance with orders, movement of funds or assets in terms of size and monitoring that, having thresholds and triggers built into the risk management systems, alerts put in place. I think when one looks at the custodian or the processing party, the courts will consider whether they've taken reasonable steps and appear to have made efforts, or are they really an underground processor that purports to be a legitimate one when in fact its sole existence is to facilitate laundering under the pretext of being a proper processor, right? And I think that's where the questions are asked. Why aren't there risk management processes in place? Why aren't you monitoring billion-dollar transactions? And so on and so forth. And that's when the more questions are asked, then the closer the risk of liability gets.
Right, thank you very much. There's a question that's actually directed at Amanda, so I'm just going to ask it. Does Amanda have any tips for serving exchanges who base themselves in unfriendly jurisdictions? That's quite interesting.
Yeah, so that is a very interesting and a really good question. And actually, Danny, please chime in if you disagree with me, because I'd love your thoughts. But what I have heard from experienced in law enforcement and heard from some asset recovery specialists is actually sometimes exchanges in what are seemingly unfriendly jurisdictions actually respond more frequently and easier than exchanges that you would think are in friendly jurisdictions. And I'm not entirely sure why that's the case, though I'm sure people speculate. But what I would say is try first. Like don't not try to serve an exchange just because it seems like it's unfriendly jurisdiction or because it seems like it's an unregulated jurisdiction. There are exchanges that are trying to be compliant or maybe they're not trying to be compliant, but they're happy to kind of act against a customer to keep attention off of maybe what they're doing, like to kind of help you and get you away as quickly as possible. There's a myriad number of reasons. I would just say, if you don't know how to get in touch with an exchange, reach out to a Siad, a Danny, people who have been in this space, who are active, who know how to do this. Because again, the time it's going to take you to figure out what some folks have already figured out through kind of trial and error, and knowing like the folks who know like which exchanges and like what's worth your time, what's the best efforts, what's worth kind of going down the rabbit hole. If you've lost X dollars, like, is it worth spending half X to try to recover given like your odds of recovery? And sometimes talking to experts about your chances of recovery, frankly, is the best investment you'll make, because some exchanges, a Danny or a Siad may know off the top of their head, you're not going to get any response there. That's going to be a black hole. You're going to throw good money after bad, right? Having those conversations is what's so critical so early on. So, the answer is it may not be what you think, which is why it's so important to kind of talk to the folks who know.
Yeah, no,
I would just add on that a lot of times you will see on the website or whatever that the exchange is actually located in what would be called unfriendly or remote jurisdictions. But really, that's just a place of incorporation or whatever it is for tax reasons or other reasons. Quite often, the operators of the exchange are sitting maybe in London, in Singapore, in Hong Kong, in New York. And we're really looking at the legitimacy of the players behind, and not so much where they're incorporated. The second point I want to make is that as far as Singapore courts are concerned, and I think the position should be similar whether it's in the common law jurisdictions, they will grant in cases like this an order for substituted service by way of emails, right? So there's no real question or difficulty in service.
And that's a huge advantage that that asset recovery specialists have, because the law enforcement side is infinitely slower. Like to go government to government with MLAT requests, this is where the private side can just absolutely smoke the government. So like when we talk about the concurrent paths and the benefits to each, Danny makes an incredible point. Like this is where you really want to kind of use the best of the one and use the best of the other to get where you need to be. Siad, I didn't mean to cut you off. Go ahead.
No. You that's exactly what I was about to say. So yeah, fantastic. Thank you for saying that, Amanda. But just in addition to that, I think you're right. We found some exchanges that just is so easy and you get the information as quick as possible. And then we've had other instances where it's just been like extremely difficult to be able to sort of navigate and get hold of them. Or when they do, it's really slow. So I fully take that on board, and I think you're absolutely right on that. Well, look, given that we have now approached the end and it's pretty much 2:15 and everybody is entitled to return back to work or their cup of tea, I think now is a suitable time to bring the webinar to an end. I want to thank all of the panelists who have taken out their time to share their insights and experiences. And I'm very grateful to you, the audience, who have attended and submitted questions and have listened patiently for an hour and 15 minutes. What I would say is, unfortunately, we couldn't go through all of the questions, but please do feel free to email any one of us directly if you do have any queries or comments. But for now, thank you so much, everyone. Stay safe and take care.